evening to one and all. I am Advocate Devul Dighe, and as you all are aware, I will be today giving a presentation on the topic legal mechanisms of recovery available for MSMEs and contractual implications. But before I start, I would just like to give a small background about my profile. I am Advocate Devul Dighe, practicing in Bombay High Court. I practice in all types of civil, commercial, contractual dispute matters, including property matters, and also I deal with a lot of succession matters and insolvency matters and corporate criminal matters as well. Firstly, before starting with the topic of today, I would like to thank Mr. Nilesh Barot and his entire team for giving me this opportunity. Now, a short brief background about FMJPI. FMJPI is one of the largest and biggest network dedicated only to facilities management industry with vision and mission in the mind of Mr. Nilesh Barot, which he had started in the year 2015. Today, FMJPI represents entire facilities management industry and supporting industry, including people across India for end-to-end solutions of any kind of requirements relating to FM industry. Now, starting with our topic, legal mechanisms of recovery available for MSME and contractual implications. I will be dividing my webinar into two parts. Firstly, the legal mechanisms of recovery available for MSME, and second part is about the contractual implications. So just starting with the topic, firstly there are four kinds of legal mechanisms that are available for recovery. Three are general mechanisms and one is a special mechanism available only for MSMEs. I will be first dealing with the general mechanisms, just because you will be able to appreciate what are the advantages and rights that are given to MSMEs under the MSME Act, in contrast to all these general mechanisms available, and what are the pros and cons and different attributes of each of these mechanisms. So starting with this first general category of or mechanism of recovery. Hello. हेलो 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 ओके तो હું થોડું લાઈવ બોલું. So firstly, dealing with the general mechanisms that are available for MSME, the first mechanism is the recovery suit, or what we popularly call as commercial suits. Now, as you all must be knowing that these suits are of general nature. When you have any recovery to be made from any party, you may file a commercial suit before any civil court. Now, here one of the most important aspect to be remembered by any person, not only an MSME, is the jurisdiction clause, which is generally there in all these purchase orders or in the invoices that you may be providing to your clients. It is very important to go through them and be aware that what is the jurisdiction that the other side has selected. For example, if the person to whom you are supplying goods is based in Kanpur, and if he writes that okay, these disputes, if any between us, would be governed by the Kanpur courts, then irrespective of the fact that you are based in Bombay, you will have to file your suit in Kanpur. So this is a very important aspect that many people don't really pay attention to while purchase orders are raised upon MSMEs. And later on, while filing a litigation, they have to really face this trouble, because in a lot of judgments, Supreme Court has also upheld the fact that once you have agreed for an exclusive jurisdiction of a particular court, then you have to file your proceeding before only that particular court only. So this is one thing that you have to be kept in mind. So now typically commercial suits are divided into two categories. One is the general commercial suit, which you may file for any sort of recovery of money, and secondly is a summary suit. Now a summary suit, as the name suggests, is a summary procedure prescribed under the law, wherein you, based on a contract or based on your invoices or negotiable instruments, can file this case, and it doesn't matter which kind of entity by which you are governed or what is the ownership type of the other side, which is the purchaser. It doesn't matter. Now here there are three things that happens once you file your case and the other side comes before the court. You are given an opportunity to file your application and give your evidence in support, stating that there is your case is a very clear cut case, and hence the court should immediately pass an order in your favor for recovery. Now the other side will file a reply stating that whatever defenses that they have, and then thereafter the court comes to three conclusions, either of the three conclusions. One, if the court is of the opinion that the other side has given no defense at all, then you will be given straight away an order for recovery of money. So there and there itself you win the case without going through exhaustive trial procedure. Secondly, if the other side is able to convince the court that it has some defense, but that may not be substantive enough, then the court may put it to such terms as it deems fit. Here, typically, the court directs the other side to deposit the amount which you have claimed as an MSME or as any person who wants to recover money. So, there you are sort of safe in a sense that the amount that you have claimed is deposited with the court as the court feels appropriate, and in the event that you win the case, you may have the option of withdrawing these amounts and satisfying the recovery decree that is passed in your favor, instead of battling it around, and then eventually if you are not able to get money out of it, if the company goes to insolvency, and your decree getting frustrated. So you are rest assured that you will get some of the monies that you have claimed. Third is, if the other side is able to substantiate no, it has a really good defense, then you have to go under the regular trial procedure and complete it. Here another important thing to be borne in mind at the outset, whatever may be your nature of legal proceedings, your limitation period is only 3 years. That means that you have to file your case within 3 years from the date when the amount became due and payable to you. Now, for example, if you supplied goods on 15 January 2021 and you gave a 15-day credit period to the other side, then you have to file your case from 3 years from 30th June 2021, that is after expiry of your credit period. So within 3 years, that would mean that you have to file your case on or before 30th June 2024. If you don't file your case within the said period, you will lose your right to file your case and recover your money forever. So this is one of the things firstly you have to bear in mind while you file any kind of legal proceeding for recovery of money, and which is very important that people really let go. After 2 years, 3 years, they realize that now I have to want to take an action for recovery. If you miss this bus, you miss it forever. There are only two exceptional rules to this. General rules to this is the fact that the other side, if it gives you partial payments from time to time, then with each partial payment in a running account, your that 3-year period would be reckoned from the each part payment. So if at all there are part payments being made, then you can calculate 3 years period from that each part payment that the other side has made. So for example, continuing with the earlier example, if on 30th June 2021 your debt became due and the other side makes you a payment on 30th December 2021, then you can file your case 3 years from 30th December 2021, that is 30th December 2024. Second exception to this is if the other side, that is the purchaser, gives you an acknowledgement in writing confirming that this debt is due and payable to you, this amount is due and payable to you, then from such date of that acknowledgement, you will have another period of 3 years to file your case. Similar example, if on 30th December 2021, if you receive an acknowledgement from the other side stating that yes, this is the amount and this is the amount due and payable to you, then you can file your case 3 years from 30th December 2021. So these are the two exceptions to that. Now coming quickly to the second mechanism of recovery that is available for MSMEs and in general for everybody is an arbitration procedure. And this is important because the fourth mechanism that we will be discussing, which is exclusively for MSMEs, govern the disputes are decided by means of arbitration only. Only certain special provisions are made therein. So it is important for you to understand what is arbitration and how does an arbitration work. Now, in second mechanism in arbitration, that is, what happens is uh, parties, if you have agreed whether at the time of supplying goods or purchasing goods or thereafter at any point in time, that your disputes would be governed by arbitration, because you do not want to get go into civil court and get with the detailed trial and spend years in litigating before the civil court, and you want to have a faster redressal of your disputes by means of arbitration, then you may specify as such in your invoice or in your purchase order, and as per that terms of that purchase order, you will be governed by the arbitration act. What happens is, in an arbitration is a very simple thing. One person or three persons, however you decide, will be appointed as an arbitrator with the consent of both the party sides. If either of the sides do not agree for an appointment of an arbitrator, you may file an application before the Honorable High Court or the District Court, as the case may be, and making a prayer for appointment of an arbitrator, and the concerned court will appoint an arbitrator. And the arbitrator, just like a court, but in a very private manner, as to say that you will not be required to go to courts, but rather have meetings with the arbitrator, formal meetings, and with those formal meetings there will be formal hearings that will be conducted by the arbitrator, with evidence being led by both the sides, and the arbitrator will decide which party is correct, and will accordingly pass the decision called as the award. Now, the award or the decision that is given by the arbitrator is final and is binding on both the parties. Now, an award of the arbitrator can be challenged before the concerned High Court or the District Court, as the case may be, and then you can take it all the way and appeal to the Supreme Court. But the difference is that an award of the arbitrator, unlike in a commercial suit, can be challenged on a very few grounds only. So an award of an arbitrator cannot be generally challenged on the entire factual matrix of the case or the evidence of the case. There are very few exceptional grounds on which you can challenge an arbitrator's award, and which is very narrow in nature. So it is very difficult to actually challenge an arbitrator's award. Typically, the time frame for arbitration is 1 year, subject to extensions that may be granted by the court from time to time. So you may make an application for extension if you do not complete arbitration within 1 year, and thereafter if courts can extend it for a further period of 6 months. Now, arbitration is typically faster. The award is binding on both the parties or all the parties, and thirdly, the award is not so easily challenged, and typically you have to deposit a certain sum of money. So typically, if MSME or any supplier gets an award in his favor, typically the court directs him to deposit at least the majority of the amount, 75% of the amount that is awarded to the MSME, as deposit before the court before challenging the decision of the arbitrator. And the arbitrator is not bound by the technicalities of the Code of Civil Procedure, which is a very exhaustive code in the manner in which civil disputes are governed. So the advantage of arbitration is that the decisions are binding, it is faster, it is less expensive, you don't have to wait before the courts for your hearings, and you will have more time to address and for redressal of disputes before the arbitrator. There are no court fees involved. Of course, you have to pay the arbitrator's fees. Typically, that is, both sides are bearing equal fees initially, subject to the outcome of the proceedings. So this is how the arbitrator decides the disputes between parties in terms of principles of natural justice. That is, it gives an opportunity to both the sides to present its case before it, and thereafter it passes an award. So the technicalities are not there as such so much in depth. Now, the third quickly I'll come to is not a direct mechanism for recovery of money, but rather an indirect mechanism which is available for the benefit of entire creditors. and that is Insolvency and Bankruptcy Code, a petition. Now, under the Insolvency and Bankruptcy Code, you can file petitions of three kinds. One is a petition by a financial creditor, which we will not be discussing in depth because that is generally by banks and financial institutions, wherein there is some loan advanced. Secondly, is the most relevant one is a Section 9 petition, as we popularly call it. That is a petition by an operational creditor, means a creditor who has given goods and services to the other party. And thirdly is a Section 10 petition, which is a petition filed by the company itself for declaring it bankrupt. So we will be only dealing with the second one, that is a Section 9 petition. Now, Section 9 petition can be filed. I repeat, you may be any kind of an entity. You may be an MSME governed, and you may be an individual, you may be an HUF, you may be a cooperative society, you may be a company, but the other side has to be a corporate entity. Means the purchaser has to be a corporate entity, either an LLP or a private limited or a public limited company, and you must provide goods and services to it, either of the goods or the services which are necessary for the other side for carrying on its business. So that is how it is. So if you, and here the thing is that, firstly you have to serve a demand notice. Demand notice has a very important relevance under the insolvency code. From the date when you serve demand notice on the other side, thereafter the other side is not allowed to raise any of the disputes, with respect to the goods or the services that you have supplied. So from the day itself when you serve the demand notice, whatever thereafter the company or the purchaser may have to say in his defense, that your goods are not of appropriate quality, they are not of appropriate warranty, the representations made by you were false, they were defective, it doesn't matter, or your services were not up to the standards, all that doesn't matter once you have served the demand notice, what the other side has to say. So this is the significance of a demand notice, that it cuts the element of a dispute, and thereafter if the other side, that is the purchaser corporate debtor, does not make you a payment within 10 days, thereafter you can file your petition to declare the other side as bankrupt. Now what happens here is, if your petition is admitted, if there is no dispute prior to the demand notice, there is a insolvency process that is triggered with respect to the corporate entity, that is the purchaser, for the benefit of all creditors, and there is a stopwatch effect, that is what we call it in legal terms, in a sense that there will be a moratorium, as in there will be no proceedings that can be filed against this entity after the admission of that petition. There will be an insolvency professional who will be appointed to take care of this company and continue the company as a going concern. It will collate claims of all creditors, verify the assets, take the assets in the custody, and see if there is any prospective bidder for this company who is willing to bid and take over this company and pay debts in a manner that is laid down in the code, that is at least pay something more that would have been paid in the event of liquidation of the company. Thereafter, if there is somebody who is interested, the COC will approve the plan if it deems fit. COCs typically comprise of financial creditors, not of the operational creditors. If it decides to approve the plan, then the plan is approved and the payment will be made as per the plan. If it does not decide for the approval, then the company goes under the liquidation, where all the assets are sold and creditors are paid as per the manner laid down in section 53 of the code. Now here I will quickly come to the benefits that are given to the MSME, and these are the important parts. Now here, if the other side, as in the purchaser, is an MSME which goes under bankruptcy, then the only exceptional benefit that is available to MSME is that the promoters of the MSME, unlike any other entity, are able to bid for their own company. So supposedly if your MSME, which is a company, goes under bankruptcy, then you can take back control of your company by submitting a resolution plan for it, which is not permissible in case of any other type of entity. If the corporate debtor is not an MSME, the promoters are debarred from taking back the control of their own company. But if it's an MSME, then definitely you can bid for your own company, and if your plan is approved by the members of the committee of creditors who take the eventual decision, then you may get all the benefits which are permissible under the law. You may restructure your entire entity, write off all the debts in the manner as provided under the plan that you have submitted and approved by the COC, and thereby you get a fresh slate. That means all the prior proceedings that have been filed against you, all the prior claims, whether of operational creditors, whether of financial creditors, will be written off. You need to pay what you have promised under the plan and get back the control of your own entity with fresh slate. That means with entirely a new chapter that you can start of your company. All the pending claims, all the pending debt will be just written off. Nobody can claim that from you. So this is a exceptional benefit that was given to MSMEs by virtue of an amendment in the Insolvency and Bankruptcy Code. And the second benefit that is given to the MSMEs under the Insolvency and Bankruptcy Code just last year is the fact that there is a mechanism for pre-packaged insolvency of MSMEs. So if your MSME is in trouble, you foresee that you are not able to pay the debts. So instead of a third party, triggering insolvency against you because you are not able to pay your debts, you yourself can get into an arrangement with your creditors. So basically, how does it work? What happens is you file a you pass a resolution that you are not able to pay off your debts. Pass a special resolution. Thereafter, your minimum default amount to your creditors should be rupees 10 lakhs or more. You pass a special resolution. Then you file a declaration by the majority of the directors of the corporate debtor. Of course, this is available only for corporate entities, like I have said. You file a declaration by the majority of directors stating that, one, this is not to defraud any creditors. Secondly, which is the insolvency professional whom you wish to appoint as resolution professional. And once you file this application, your application will be given priority to any other application that will be filed by any other creditor against you. Secondly, you will also, the credit directors also have to give a declaration that none of these transactions that MSME has entered is to defraud its creditors, or which are entered into in a view to siphon off the monies or to give benefit to any particular related parties of the promoters of the MSMEs. So you have to give a declaration that you have not done any transactions that are fraudulent in nature, by which you are not taking away assets of the company, thereby depriving creditors from the assets of the company. Thereafter, you take the consent of 66% of your financial creditors prior, that whether they are acceptable to the restructuring what you have proposed. You will prepare a detailed plan in advance before even you file your application. If they give you a consent for it, then you will directly go to NCLT, submit your plan, submit the consent. Thereafter, again the creditors will vote in favor of the plan, or they may even if you fail to abide by the plan, or you show your willingness not to abide by the plan, then they may even call for plans from any other competitors as it deems fit. And thereafter, if your plan is approved by 66% or more financial creditors, then your plan will be approved, and then the adjudicating authority will pass an order for approval of the plan. If the plan is not successful, and it is found that you try to defraud creditors or you did not implement the plan willingly, then the company will be liquidated. Here, there is one exception again provided for the benefit of MSMEs who must be your suppliers, is the fact that entire dues of operational creditors means those creditors which have supplied you with goods and services must be paid in full. So unlike in normal bankruptcy where you may not pay 100% or may not pay anything to operational creditors, here if you want to go for a pre-packaged insolvency, you have to pay 100% of amounts to the your operational creditors. Otherwise, the COC, that is Committee of Creditors, are at the liberty to call for any competitive plans from any other person. So they may invite plans from any other person who would be interested in taking over your own company, and therefore you will have to compete with them. So that is one exception that is provided in a safeguard, that if you want to have a pre-packed insolvency, pay your operational creditors in full. You may determine the manner in which you want to restructure your financial debts and your debts with banks and financial institutions, but pay your operational creditors in full. Now coming back to the most important part is the fourth mechanism of recovery that is available exclusively for MSME. Again, here it doesn't matter, unlike the previous one, whether you are a corporate debtor, whether you are a company, private limited, individual, it doesn't matter what kind of an entity you are, you must be an MSME. And what we have particularly time and time again seen in our practice is, just to satisfy yourself into the definition of MSME and to avail this remedy under the MSME Act, you must, and I repeat, you must be having an Udyog Aadhar number or an Udyam registration. Without having an Udyam Aadhar or Udyam certificate, you will not be able to avail these benefits, under the MSME Act. Now, what does the MSME Act particularly say? Now, the MSME Act basically gives you a remedy under Chapter 5, which is a special remedy. Why is it a special remedy? Because it doesn't matter even if the other side has subjected you to an exclusive jurisdiction of maybe a Kanpur court and you are based in Bombay, whether the other side has said that there will be an arbitration, with arbitration being held in Kanpur, far away from your place where you are functioning. It doesn't matter what they must have said, but if you choose to avail remedy under the MSME Act, that is, if you are an MSME and you have to recover money from any other party, then you may opt for this benefit that is given, a mechanism that is given under the MSME Act, and avail this remedy. Now, what is this remedy? Of course, I am not getting into the definitions of MSME, you all are aware about it. So, I will just come back to the mechanism that is given. So, under the MSME Act, you will first, there is a establishment called as MSME FC, that is Micro, Small and Medium Enterprises Facilitation Council. This typically consists of state government officers, typically tehsildars and other people. There are 3 to 5 members in this council which are appointed by the concerned government. And here what you have to do is, you have to, if you want to avail this mechanism, you will have to file an application before the concerned MSME FC, which has jurisdiction where the supplier, as in where when you have to recover money, is where you are located. So you here you have an advantage that you are able to fight in your own backyard, and you cannot be forced to fight in the backyard of the purchaser. You will be governed by that particular MSME FC. You have to file your application before it. Now, what will this MSME FC will do? Of course, this has to be filed beyond the appointed date. Now, what is the appointed date under the Act? So, if you are supplying goods or giving services, and if it's accepted by the other side in writing, then that will be your appointed date in writing. Suppose if they do not accept willingly, that or do not give you a written confirmation that your goods or services are accepted, then on the expiry of 15 days from the date when you have supplied goods becomes your date of appointed date. So if they do not send you any confirmation that whether your goods are accepted or rejected, then you have to wait for 15 days. After 15 days, it is deemed that they have accepted your goods or your services, and therefore you can thereafter file your petition. Now suppose if there is a third alternative is if they really dispute your case, they write to you that your goods are not of proper particular quality or quantity, or your services were not proper, then you have to remove those goods, the defect in those goods or deficiency in that service. And once you remove that deficiency, again they will have a 15 days period to accept or reject it. If they do not accept or reject it, after expiry of 15 days, it is deemed that your services they have accepted with the whatever disputes they had have been resolved, and you are able to file your case before the MSME FC. Now what does MSME FC do once it receives your application? Now, once it receives your application, it will first try to amicably resolve your disputes by means called conciliation, as per the Arbitration and Conciliation Act. Hence I was referring to the entire procedure under Arbitration Act, because here what happens is first there will be a conciliation done. There is a 90-day period provided for conciliation. Now here the MSMEFC itself would do a conciliation, or it may refer to any institution to conduct conciliation as per the Arbitration and Conciliation Act, thereby trying to amicably settle disputes between parties within a period of 90 days. If parties amicably settle the disputes within 90 days, then a consent award is passed by the conciliator, or MSMEFC if itself chooses to act as a conciliator, and that award is binding on the parties. So you may negotiate, you may agree for a little lesser interest for the delayed payments, and you may work out your settlement. If parties eventually do not settle within the stipulated period of 90 days, and if the conciliation fails, then you have the MSMEFC will subject you to arbitration. Now here the advantage of arbitration here is MSMEFC either itself will be conducting arbitration and itself will be acting as an arbitrator, unlike in private arbitrations a third party is appointed. Secondly, MSMEFC may even refer you to an institution, and it will conduct arbitration as per Arbitration and Conciliation Act. That again the period remains the same, entire procedure of the arbitration remains the same, which I have already specified. But the advantage that you get over here is that it is pro MSMEs. Secondly, it is a very accommodative procedure. Again, like I said, you don't have to go into the technicalities of the Code of Civil Procedure. You will submit your case, they will submit your case, you will need whatever documents that you have in your favor, and there will be a detailed arbitration that is conducted, and an award is passed. Again, award is subject to same narrow grounds of appeal as it's provided under the Arbitration Act. But there is again one benefit that is available for MSMEs, that if an MSME gets an award in its favor for recovery of money, and if the other side chooses to challenge it, then they have to mandatorily deposit the amount that has been ordered in favor of MSME before the court, and even pending that appeal before the Honorable High Court or whichever district court, if it is pending in district court, depending upon where that MSME is located, these amounts can be pending appeal be withdrawn by you. So you may not actually await the outcome of proceedings, but you may be able to withdraw these amounts pending an appeal that is filed by the other side, subject to whatever terms that the honorable court may put you to. So here is a exceptional distinctions there. One, you fight in your own backyard, irrespective of whatever the other side may have mentioned in their contract that you have to fight in Kanpur. No, if you are based in Mumbai, you will fight at Mumbai, whatever they may have said. Whatever may have been stipulated in any other law, you will fight in Mumbai. Secondly, you will there are stringent timelines. Thirdly, there is a council which is pro MSMEs, which understands the difficulties faced by MSMEs. There is a faster means of disputes through conciliation and arbitration. Fourthly, if you are successful, it is very difficult to challenge the award. If the other side even challenges that award, they have to deposit the entire amount while challenging the award. You may even pending the appeal, you can withdraw the amount. Thirdly, also another significant benefit is you are MSMEs are entitled to an interest thrice the rate of bank rate prescribed by RBI, which is usually about 14 to 16 17%. So even if your contract does not specify that MSMEs are entitled to interest at a at a particular rate of interest, or they are not at all entitled to interest for the delayed payments. MSME Act gives you that protection that irrespective of whatever may have been mentioned in the contract, or it may not have been mentioned in the contract that you are not entitled to get any interest. MSME Act prevails over all of them, and you are entitled under the law to claim interest beyond the credit period at the interest rate of 14 to 17%, that is three times the rate prescribed by RBI, irrespective of whatever has been specified. So you are entitled to your interest. Of course, you are entitled to this irrespective of the fact that you may choose to file a recovery suit, you may go to insolvency court, you may file a petition before MSME FC. So that is irrespective, you are entitled to interest. Secondly, these concepts of deemed acceptance of goods comes into the picture. So if the other side does not raise a dispute, you may presume that he has impliedly accepted your goods or your services and file your case. Thirdly, what benefit you have been given is the fact that if the other side is subject to audit of his accounts, then every time the other side, if it does not make you payment, has to specify in his audited financial statements entire list of MSMEs to whom he has to make payment. He has to specify, he has to give a bifurcation as to principal amount that has to be paid to an MSME, interest that has to be paid to an MSME, what is the delay in payment of an interest. And this is of some significance because under the law, now with recent judgments of the Honorable Supreme Court, an acknowledgement in financial statements is an acknowledgement of debt. So, if the other side is subject to accounts, it has to mandatorily disclose what is amount due to MSME. Therefore, it becomes an admission of debt by them if it's unqualified. And if it's an admission of debt, then it becomes very easy for you to pursue your recovery case, because once they specify your name in the balance sheet that yes, I have to owe this amount to an XYZ MSME, they have to pay that. They have to account for the penal interest that is provided under the act, and you get the advantage of an acknowledgement or an admission from the other side that this amount is due to you, and it revives your limitation period. So every time they acknowledge this in their yearly financial statement, you get 3 years additional time to file your case. And this is the only benefit that is given to the MSMEs, because the law clearly states that you have to specify what is the amount due to each of the MSMEs. And therefore, you can also write to the statutory auditors of the other side stipulating the fact that they have not made payment to an MSME. So please mention your amount in the audited financial statements of the other side, give an audit qualification, which is a kind of a stigma on the other side, and specify my amounts. And secondly, whatever interest rate that they are paying to MSMEs is not allowed as a deduction under the Income Tax Act. So if the other side is paying an interest to the MSME because it has made a delayed payment, they will not be given the benefit of that interest payment for taxation purposes as well. So they are penalized from both the ends. One is that the fact that they cannot claim this as a deduction, so they do not get taxation benefits. Their profits will be shown higher. You will not be able to take interest payment as a deduction under the law, thereby showing lesser profits and paying lesser tax. So you have to pay more profits. Secondly, you will get an audit qualification. The government will ask you for a detailed reasons as to why you are not paying MSME. Fourth, you will have an acknowledgement of debt in the balance sheet of the other side, which makes fighting your case very much easy. This is the advantages and protections that have been given to you under the MSME Act, and there is this special mechanism, like I said, which is available to you for recovering your debts. Of course, every time MSME FC may not be the most suitable remedy. That you will have to consult your lawyer as to which remedy will be beneficial for you. But definitely, an MSME FC gives you a very effective alternate remedy to fight in your own backyard, to get a higher percentage of interest, and to fight at your comfort, and to fight at have a faster resolution of your dispute and save cost. That is also one of the essential benefits of MSME. You don't have to pay hefty court fees. Your lawyers can draft you petitions and give it to you, and you may appear on the day-to-day hearings that are held, so thereby saving a lot of cost and time for you. Now I will talk about contractual implications. Of course, I'm not getting into the very intricate technicalities, because that will make this webinar very much complex. The idea is to keep the entire presentation simple and crisp. So now I'll come to certain contractual implications. Here I will be basically discussing about certain benefits or certain contractual terms that must be incorporated in your invoices, or that you must be aware while the other side raises a purchase order about upon an MSME upon you. And this is very much important, because 90% of the times we see the fact that people do not really pay attention to these terms of invoices or terms of contracts, and thereafter when there is time to litigate, they really suffer. So first and foremost advice to all MSMEs is specify an interest clause in your invoice, that if the particular supplier purchaser does not make you payment within the due date, you will charge an interest, whatever, 18%, 24%, whatever you deem fit, but specify an interest clause in your invoice. Absolutely necessary. Many MSMEs, many people, suppliers till date do not do this. So which is very sad thing that I come across, because if you're getting an interest at 18-24%, and which now a lot of courts have opined that once you have such clauses in your invoices, they are binding, and these are commercial terms, so they must be adhered to. So specify that. Second and very important thing is, under the law, see if the other side has specified anything in relation to passing of risk and title in goods. Now this is very much important, because what happens is, these dynamic concepts are something an ordinary person is not aware. Now when the risk, if the other side has mentioned, for example, I'll give you, if you are supplying goods from Mumbai to Kanpur, and if the other side in his purchase order says that the risk in goods is of the supplier, that is the MSME, till the time the goods reaches Kanpur to his warehouse or his godown or wherever. What happens is, if there is any loss, any damage, anything that happens to the goods in transit, from the time it leaves from your premises till the time it reaches his premises, you are responsible for it. You have to bear the loss. Therefore, you are mandated to have insurance for these goods. If something happens, he will straight away raise his hands, irrespective of the fact that he may have chosen the particular transport agency, but you will suffer. So this is very much important, and even otherwise, the law presumes that the risk passes only once the goods are beyond your control. So these are concepts that you must be very well aware about. Again, similar thing for title. You know, the stipulations in the contract with respect to passing of title is very much important. As an MSME, you would of course want that the title passes on to the concerned buyer only when he has made you an absolute payment, complete payment, so that in the event of his bankruptcy or some issues, you are in control to take back your goods. Of course, this depends on the facts and circumstances of the case, but you have to consult your lawyer, but at the same time you must be aware about these concepts. Secondly, you must be aware about your rights. What are your rights, and you must incorporate them in your invoices. So for example, you may, if you specify in your invoices, you may reserve the right to recall your goods. If in transit you realize that the other side is not making payment of the goods, if there is an agreement between you that he will make an advance payment, he doesn't make the advance payment while the goods are in transit, therefore you have the authority to recall these goods back. Secondly, you may also, by making a specific stipulation, have lien on your own goods. Therefore, you may keep the control or keep the goods in your possession till the time the other side does not make you payment. Of course, this is till the time the goods does not reach to him in his premises, or it does not come within his control. So these are all dynamic concepts. So again, this is something you have to be aware about, and you must have a properly drafted invoice clause or terms and conditions in your invoices, and you must please peruse the purchase order that has been raised upon you. Third thing, again, fourth thing you have to be very well aware about is this exclusive jurisdiction clause. Of course, if you go under MSME Act, that may not apply, but then if you are going under any other remedy that is binding upon you, so you must be careful. You must be even careful if the other side has, if there is an arbitration, if the other side has chosen a particular place of arbitration. Place of arbitration means where the arbitration, or the where this, if I may use a Hindi word, where will this disputes be adjudicated, actually be heard physically, where will you meet the arbitrator, advance your arguments. This is again important because of course the other side would want to keep all this at his own backyard, where he is comfortable. You may want to have this at your own backyard, or you may want to have it at some neutral place which is convenient for you to also travel, because that is binding upon you. So if the other side specifies that let's have this at Delhi, then you have to travel all the way to Delhi and have this disputes redressed in Delhi. So which is something that may not be convenient to you, and hence it impacts you because your costs will escalate, and it discourages you for fighting for smaller amount. So make sure you are aware if there are such clauses in the purchase order raised by the other side. Simultaneously, you would want to incorporate clauses in your invoices which are beneficial to you. There are so many of them. Uh, like I gave, like I am giving the example, you may want to keep an exclusive jurisdiction clause to Mumbai courts where you are comfortable litigating, or give an arbitration place of arbitration as Mumbai where you can conveniently fight, and not the other side, because ultimately the other side has your goods, he has a better bargaining position to fight, while your position is a little bit weaker to fight when you don't have your money. Again, I'll give you some quick tips. uh, uh, there is a provision in the statute as to whether you whose liability remains upon the goods if the goods are of not, or what are the warranties that you want to give under the good. Now under the Sale of Goods Act, there are certain warranties that are implied, while you may not want to have those implied warranties given to the other side, simply because you may not know what use or what is the particular purpose for which the other side is using your particular goods or your services. So you may incorporate clauses in your invoices as to that, that there is no implied warranty, there is no implied guarantee for a particular use, which your goods are available or beneficial. So you ideally would not want to give representations which you you don't think that that would be beneficial to you. You may not know what is the other side purchasing your goods for, or what purpose he is going to use it. So you may want to incorporate, depending upon what goods you are dealing with, that which warranties you want to give out and which warranties you do not want to give out, because ultimately if you represent an implied warranty, or there is a legal warranty, then you are bound by it. And if the goods suffer with any particular defect during that warranty period, just like when you buy television, printers, and if there is a defect, then there is a obligation by the supplier such as your manufacturers of TV, MI and all, they have to replace it. So same manner you will have to replace it, which you may not ideally want to do. So under the Sale of Goods Act, if you specify that your goods are not going to be of a particular warranty or a particular level or particular use, and you leave these obligations upon the buyer, that he is satisfied himself that your goods are correct, then you know uh, it will safeguard you from him making unnecessary claims against you for defeating your right of payment. Thirdly, most importantly, have this practice of taking confirmation of accounts from the other side in every 3 to 6 months. Very important practice. It acts as an admission of debt. Your case will become very easy. And secondly, the other side loses its right to defend himself as far as the amount acknowledged under the confirmation of accounts is concerned. So those are the very beneficial advantage that you get. So have confirmation of accounts from the other side. Also, one of the practices that you should follow is specify what is the exact description of goods that you have undertaken to supply. Many a times there is very general description given, but at the back side of your invoice you must give a detailed description of your product, and specify that the general practices of the custom may or may not be applicable to you. Again, very important thing that really gives you an advantage, uh, reduces the scope that the other side gets to dispute your services or your goods. And the last and one of the most important things is, you know specify under your invoices that how the payment has to be made to you. And as far as possible, when other side, you will come across this, I'm sure, day in and day out, that the other side is in some financial difficulty, seek some time for making payment. You may, of course, to maintain your relationships, want to give the other side that benefit. So you may give that benefit, but try and take post dated checks from the other side in that event, which again gives you an extension of limitation. It acts as a very strong evidence of proving your case. And thirdly, it gives you the right to sue him in a criminal manner as well as in a civil manner, and therefore exert pressure and get faster recovery of your amounts due from him. And it acts as an advantage to him that you are giving him certain more leverage to make payment. So this is what I would always recommend. And in case of any difficulties, all of you are very well welcomed to reach me out. My contact number is 8169308320, and my email ID is advdevul @gmail.com. That is advdevul @gmail.com. And if you have any queries, I will be more than happy to address them. And if you have any doubts or queries, you may feel free to reach me out. I would once again, before concluding, like to thank Mr. Nilesh Barot and his entire team for giving me this opportunity. I hope you have found my webinar very useful. And in case you have any queries, you want to understand more about any of the legal mechanisms available to you, please feel free to reach me out. Thank you so much.